Good evening, ladies and gentlemen. Welcome to the 11th session of Constitutional Revival with Royal Alexander. It's hard to believe how quickly we got to 11, but time flies when you're having fun. I again thank everyone who has contributed to keep us online. We are good for this year, and I thank you, because otherwise we wouldn't be able to be on the web with this program. So thank you again for contributing. I hope everybody had a happy Thanksgiving. I think in particular this year, we should remember to be grateful, and I think we do remember to be grateful to live in this country. I feel like in many ways we are having to fight for our basic freedoms, the ones that are clearly outlined in our Constitution that we've been going through, but yet are constantly in friction with maybe the normal tensions of government, which is to always grow larger and more powerful, both of which, the desire to grow larger and more powerful, both of which our framers anticipated, which is why they put into place checks and balances and our separation of powers. But I want to say again, thank you to Joanne Woodard and to David Hagar. This, again, would not come together without them. We never would have gotten going or continued going. David's company is Beyond Innovative Technologies and Consulting, and he does a great job for us. Anyone, by the way, wishing to review the material, I know sometimes people can't see everyone at exactly the time it's occurring, but you can go to my YouTube channel, Constitutional Revival with Royal Alexander, and that should keep you on track, as well as if you ever have a question that you want me to answer, please send it to constitution.royalalexander@gmail.com. Again, constitution.royalalexander@gmail.com. Tonight, we are going to pick up with the 10th Amendment, but we're going to do that in just a minute, because you know how important I think it is as we go through this material for me to comment on things that are happening right now in our world. And this past week, the United States Supreme Court, unfortunately, in only a 5-4 decision, told the governor of New York, but not just him, governors across the United States, that sometimes you can go too far. And Governor Cuomo, unsurprisingly, it would be Governor Cuomo, you have gone too far. So I wrote an article, which I'm going to submit for publication, as I do often, to the Hayride, and it's Louisiana's conservative website if you haven't heard of it. Just like Moon Griffon is Louisiana's conservative talk radio, Scott McKay at the Hayride often publishes my articles. But I want you to hear the article. I'm going to read the article to you because I want you to hear how I see this, and it's not long. The title of it is, and again, this is back to First Amendment, free exercise of religion, okay? What's its counterpoint? The counterpoint to the free exercise clause, the establishment clause. Free exercise, yes. Too much establishment, no. So that's where they always conflict in the First Amendment. And we did the First Amendment several months ago now, but we're going back to it because of what happened this past week. And it's important to me that you understand what the Supreme Court did in this decision about 4 days ago. It's entitled, Supreme Court Protects Religious Liberty, but Battle is Not Over. That's the title. Supreme Court Protects Religious Liberty, but the battle is not over. And then I quote, there is no world, this is Justice Neil Gorsuch, Justice Gorsuch, quote, in his concurrence, he had a very powerful concurrence opinion. Quote, there is no world in which the Constitution tolerates color-coded executive edicts. In New York, they put areas that are supposed to be the most dangerous about COVID, bright red, orange, yellow, green, and other codes. That's what he means by color-coded. They put parts of the city that they say are the most dangerous from a standpoint of catching COVID or already having caught COVID in the state of New York. in color-coded areas. So now what Justice Gorsuch wrote will make more sense to you. There is no world in which the Constitution tolerates color-coded executive edicts that reopen liquor stores and bike shops, but shutter, meaning close, churches, synagogues, and mosques. Okay? Again, there is no world in which the Constitution tolerates color-coded executive edicts, but from the governor. He's the executive of that state. Edicts is basically a fiat, a mandate. Executive edicts that reopen liquor stores and bike shops, but shutter, but close churches, synagogues, and mosques. That's very good writing. I think it's colorful writing, but it's easy to follow writing. And then I begin the article. This Supreme Court decision involves the Catholic Diocese of Brooklyn and the Agudath Israel of America, which is an Orthodox Jewish group. The Catholic Diocese of Brooklyn, one of the oldest Catholic dioceses in America, and the Agudath Israel of America, an Orthodox religious group. They're the ones who are the plaintiffs filing the suit that reached the Supreme Court. It involves them and their opposition to restrictions limiting religious services to 10 people in some areas and 25 people in others. Both groups essentially argued that the new COVID-19 regulations imposed by New York Governor Andrew Cuomo target houses of worship in a much more burdensome and restrictive manner than other non-religious commercial facilities. Now, listen to that sentence again. This is the heart of the issue of what the Supreme Court did 4 days ago, or is it 3 days ago now? Thanksgiving was Thursday, Friday, Saturday, Sunday, 4 days ago. Here it is. Both groups, those two groups, the plaintiffs, the Catholics and the Jewish people, both groups essentially argued that the new COVID-19 regulations imposed by New York Governor Andrew Cuomo target, that word's important in constitutional analysis, target houses of worship in a much more burdensome and restrictive manner than other non-religious commercial facilities. Okay, keep that sentence in mind. At its core, back to my article, at its core, this decision by the United States Supreme Court powerfully underscores the principle that a public health emergency cannot be used as a valid reason to target, there's that word again, to target religious activities with draconian restrictions, which just means huge, monumental, with draconian restrictions while allowing secular businesses and commercial entities that are deemed essential. You've heard about the essential businesses, and I say in parentheses, and apparently even some favored non-essential businesses. They get to keep operating too, to proceed in their typical fashion. So here's that sentence again. The U.S. Supreme Court powerfully underscores the principle that a public health emergency cannot be used as a valid reason to target religious activities with draconian restrictions while allowing secular businesses and commercial entities that are deemed essential, and some even not essential, but preferred, to continue in their normal course of business. Can't do it. Rather, the court makes clear here that what is deemed quote unquote safe for liquor stores, bike shops, and massage parlors must also be deemed safe for churches and synagogues. Okay? Don't be saying you can go to a liquor store or a massage parlor or a bike shop or go see your acupuncturist. They're allowed to, acupuncturist. You can't do all that and say it's okay for people to be around each other, but then say, oh, you houses of worship, Catholic Church, Jewish synagogue, a mosque, can't go there. The court's saying you can't say that. There's no principal distinction here, except you, the governor, Cuomo, decided that what's going on in these houses of worship is somehow less important or less essential than what's going on at a liquor store or a bike shop. And I go into further detail right here. In a succinct and penetrating, because it was, concurrence. And some of the best writing in Supreme Court decisions are in concurrences. It's like a particular justice will want to join the majority decision, but sometimes they don't get assigned the majority decision. But in addition to supporting the majority decision, the outcome, they also want to say something specifically themselves. So sometimes the concurrences actually offer more insight, and not just in the area of the First Amendment, but across all of Supreme Court decision making. A lot of times the concurrences, and in fact, many times the dissents are so powerful. A lot of times the dissents, years down the road, end up becoming the majority opinion. Justice Scalia wrote some tremendous dissents that he got outvoted, but down the road, he laid such a strong marker down. Keep in mind, these cases last forever. So somebody researching it is going to see the majority opinion and his dissent, just like every law student in America who's reading constitutional law cases is going to see the majority opinion. Then they're going to see Justice Scalia's dissent, or hear Justice Gorsuch's concurrence. Okay, I just want you to know that. In a succinct and penetrating concurrence opinion, Justice Gorsuch reasoned his way through the issue. And this is what they're supposed to do. They're not supposed to be making things up. They're supposed to see what the constitutional law is or what a federal statute is, and then apply it. Don't be making stuff up. That's not your role. That's the role of the legislative branch with help from the executive. It's not the role of a judge, period. That's judicial activism, which we have been over. Anyway, back to Justice Gorsuch. This is how he reasoned his way through the opinion. Quote, it's like he's thinking and saying, this is why I think the way I do. Quote, people may gather inside for extended periods, in bus stations and airports, in laundromats and banks, in hardware stores and liquor shops. No apparent reason exists why people may not gather, subject to identical restrictions in churches or synagogues, especially when religious institutions have made plain that they stand ready, willing, and able to follow all the safety precautions required of essential businesses, and perhaps more besides. Churches and houses of worship may actually be willing to go further than essential businesses have to go. They may self-limit themselves even further. When a justice sees these kind of facts, that's because I've read so many constitutional law cases. When a justice sets up his reasoning like this, I've studied constitutional law for so long, I just know where the thinking is going. And again, I want you to know it. And I'm going to repeat it because I know you don't have this opinion in front of you. Here's Justice Gorsuch reasoning his way through this again. And again, I want you to know what we're doing right now is straight up constitutional interpretation. It is. Just like if you were in law school tonight. All right? You are in law school. You're in Royals Law School. But listen, quote, Justice Gorsuch, people may gather inside for extended periods in bus stations and airports, in laundromats and banks, in hardware stores and liquor shops. No apparent reason, meaning I've looked at the record. Me and my law clerks have looked all through the record. that's before this court to decide this case, because they're limited to just the record, by the way, nothing else. They got to look at the record. Where was it? No apparent reason exists why people may not gather subject to identical restrictions. When a judge says, I mean, he's not saying equal protection, but that's what that is. Subject to identical restrictions. There's no way to distinguish the two categories, is what he's saying. Subject to identical restrictions, while people may not gather, subject to identical restrictions in churches or synagogues, especially when religious institutions have made clear that they stand ready, able, and willing to follow all safety precautions of essential businesses. And a lot of people are going to say, going to church is very essential to me. It's not the same as being on Zoom. It's just not. I mean, I'm Catholic. Being at Mass is a lot more helpful and necessary for purposes of prayer and meditation to be in person in the building. Sure, I can also watch Zoom, but it's not the same thing. And a lot of people feel like going to the Sabbath to Sunday church, or some people go to Mass or services more days of the week than that. They absolutely believe going to Mass in person is essential. My faith to me is essential. So Governor Cuomo, don't be saying that being able to go buy a bottle of wine or go to a massage parlor is more essential than my being able to go practice my faith. You're not in a position, even though you think sometimes you're God and act like one, Governor Cuomo, you are not God. And you don't get to make that determination. You're the governor. And I think it's just as essential to practice my faith as you do to allow people to go buy a new 10-speed or to go buy a bottle of wine. Anyway, here's Gorsuch. They're willing to follow all the safety precautions required of essential businesses and perhaps more. Churches may go a step further than even the amount of requirements of essential businesses. Say you can only have 25 per 100. They may just say, we're only going to have 20 per 100. Even though the law makes us have no more than 25, we're going to say, for our own safety, we're only going to let 20, not 25 come in, even though the regulation allows up to 25. We're just going to have 20. That's what it means when it says these houses of worship may go even further. They're totally willing to try to participate in the governor's regulation, but you don't get to just shut them down. You may think you do for a while, but that's why we have the Supreme Court, and more importantly, that's why we have free exercise right there in the First Amendment, Governor Cuomo, right there in the First Amendment. Hence, and it's beautiful writing, and I want you to hear it. Hence, Justice Gorsuch continues, quote, the only explanation for treating religious services differently seems to be a judgment that what happens there just isn't as essential as what happens in secular spaces, commercial spaces. Indeed, the governor, I love when the Supreme Court kind of smacks somebody directly, like we always have to write kind of vaguely, not about the law, but these opinions are going to be here for eternity. So we don't want to smack someone down, except sometimes when they actually need to be smacked down just a little bit. Justice Gorsuch, listen, indeed, the governor is remarkably frank. Just in case anybody wondered what we were talking about here, we're talking about the governor of New York, Cuomo. They don't say his name, but indeed, the governor is remarkably frank about this. In his judgment, laundry and liquor, travel and tools, hammers, are all essential, while traditional religious exercises are not. That, and he emphasizes it himself, that, of course, Justice Gorsuch says, is exactly the kind of discrimination the First Amendment forbids. Close quote. Now, I mean, that's the deal. Governor Cuomo doesn't get to decide what's essential. And again, indeed, the governor is remarkably frank about this. In his judgment, in Governor Cuomo's judgment, laundry and liquor, travel and tools are all, quote unquote, essential, while traditional religious exercises are not, period. That, emphasized, is exactly the kind of discrimination the First Amendment forbids. I love when the Supreme Court bows up and says it like it should be said. Now we're picking back up with my part of the article. It should be highly hopeful and heartening for believers to see a decision like this that resoundingly rejects an action by government, Cuomo, that would otherwise undermine and weaken the First Amendment's guarantee of religious liberty. Even in a health emergency, core constitutional rights may not be enjoined, which just means frozen, locked up, stopped. May not be enjoined by politicians, particularly when they are, as here, imposed in an overly broad, arbitrary, and discriminatory fashion. Overbroad, arbitrary, discriminatory. Those are all common terms of art in the area of constitutional law analysis. So I'm going to say this again. This is what's going on in this decision this past week. It's relevant, which is why I want you to know about it. And I am hopeful. It should be highly hopeful and heartening for believers to see a decision like this that resoundingly rejects. I wish the decision was more than 5-4, but the writing of the majority is resoundingly rejects an action by government that would otherwise undermine and weaken the First Amendment's guarantee of religious liberty. This last sentence is the whole point of what has gone on during this whole COVID virus. Even in a health emergency, core constitutional rights may not be enjoined, may not be blocked or stopped by politicians, particularly when they are, as here, imposed in an overly broad, arbitrary, and discriminatory fashion. We know they're overly broad because they're taking in, and the thing is, when you look at it, helps to look at these three things together: overly broad, arbitrary, and discriminatory. Why is it discriminatory? When something's arbitrary, it's essentially you're picking and choosing. Governor Cuomo here is picking and choosing wine shops, bike shops, massage parlors, acupuncturists over houses of worship. That's arbitrary. There's no principal distinction between the two, as Justice Gorsuch says, because these houses of worship are more than willing to work with the government, but you can't shut them down. You can't treat them differently when the mingling of bodies, which is the whole point of, I guess, avoiding the virus, and wearing of masks and the social distancing, is no more or less likely to be successful in a wine shop or a bike shop or at a massage parlor than it is at a church. And so you don't get to say, you know what, buying wine is just more important than going to church. No, it's not. And you, in particular, Governor Cuomo, don't get to make that decision. The framers made that decision, Governor Cuomo, 244 years ago. They took it off the table. You don't get to do that. I know you're very powerful sitting up there in New York State thinking this is the most important state and city in the world, and so I can bully people. But no, you can't. Little smackdown right here. So he gets limited. But then I go on to to pivot from this because I want you to think about something else, and I want the readers, hopefully, of my article to think about something else too. However, this is where I pivot. There is a broader question here. How far will this go? Where does government overreach in matters of religious liberty and freedom of conscience end? Where does overreach by government end when it comes to free exercise and a matter of conscience? So much, it's all wrapped up together. So much when we're talking about freedom of conscience affects free exercise of religion. Where does it end? I note that the largest LGBT organization in America has already demanded that Joe Biden, if he becomes president, which he has not become yet, they've already demanded, LGBT, that if Biden becomes president, which he has not, but if he does, that he remove accreditation of Christian schools that adhere to biblical sexuality. He wants to make it impossible for Christian schools to get accredited if they teach biblical sexuality, meaning marriage is a man and a woman, meaning probably supposed to be wait until marriage to be engaged in sexual activities, those kind of things. Merely the teaching of those things can cause a Christian school to lose its accreditation, to get it yanked, is what LGBT wants in a Biden administration, which we don't have yet. But this is another fight for free exercise of religion and freedom of conscience. LGBT, the biggest one in America, wants to remove the accreditation, because if a school, if an institution doesn't have accreditation, it's slowly going to die. I mean, why would you want to go to some institution of higher learning, for example, that's not accredited? You wouldn't. They know that that will kill it, or at least make it much more difficult. So jerk their accreditation if they merely teach biblical sexuality. No one has to agree with it, but you're saying they can't even teach it? No. That's why, even though the Supreme Court was strongly, well, I wish that decision was more than 5-4. Anyway, I'm about to address that. But that's what LGBT wants right now. Since the election, but he's not president yet, but if he were, that's what they want. This is me picking up again in my article. My point is that religious liberty has been under attack in this country for decades. In this case, this one, by a mere 5-4 decision, that means, well, I'm about to explain that. One vote, in a 5-4 decision, one vote, the Supreme Court has protected religious freedom. However, a 5-4 decision the other way, which if Ruth Bader Ginsburg was still alive, we would have had. This decision would be 5-4 the other way if Ruth Bader Ginsburg were there. And you think, as a Jewish person herself, that she would care that a conservative Orthodox Jewish group, along with the Catholic Archdiocese, are the ones asking for this relief? I don't think she would have cared at all. This decision would have been 5-4 the other way if she were still alive and Justice Barrett were not on the Supreme Court. Anyway, however, a 5-4 decision the other way would essentially, what would a 5-4 decision the other way have meant? This is what it would have meant. Had it just opposite happened and we had lost, that decision would have essentially allowed public health officials, whatever exactly that term means, public health officials to be given preference, greater authority. Public health officials would be deferred to here, be put in charge, given authority over sacred, fundamental, constitutional rights, like free exercise, that have been protected in this country for 244 years. As I say in my article, that's worrisome and concerning. To say the very least, it's worrisome and concerning. However, because I'm a very positive person, and because I know God will still bless us if we ask him to, and because we still have a constitution, and because millions of Americans are good-hearted, kind, loving, faithful people. This decision is very encouraging, but we still have a battle in front of us. And I know we will courageously rise to meet it. Okay? This decision, this 5-4 decision, allowing, smacking back Governor Cuomo's regulations is very encouraging. Absolutely. But this LGBT example I just gave is something to keep us focused. We still have a battle in front of us, and we will courageously rise to meet it. I know we will. There are millions of us who still love this country, and I mean the traditional sense of it. I mean the idea that we are a land of freedom and faith, that we are a land of freedom of conscience, the right to free exercise of religion, to be able to practice our faith, but not have the state tell us you're all going to be one faith, the Establishment Clause. Freedom of speech, my God, freedom of speech. And have we seen that one attacked in these last few months since the election? Twitter, Facebook, what's that other nut? Google. They have done, and again, I want you to know, because it's important, those are quote unquote private corporations. Twitter, Facebook, and Google are quote unquote private corporations. But I will tell you that they're so huge and they enjoy powerful federal benefits, like something called the Communications Decency Act, under which if someone who's using Facebook, if Royal gets on there one night and posts something highly defamatory of someone else, Facebook can't be sued because of the defamatory thing I, a Facebook user, has posted. That protection from liability is massive. It's given by the federal government. So my feeling is that's great. Facebook, Twitter, Google. If you say, oh no, we're private corporations, we can either print or not print what we want to, that's fine. You do that. But we're jerking that protection from you. And now when someone writes something defamatory, including yourself, you can be sued, like Nick Sandman did. Remember the boy wearing the red MAGA hat when the elderly Indian gentleman came up and started really harassing him. This way he was, God, defiled, defamed, slammed by every national media organization that wanted to believe the young boys wearing MAGA hats had to be racist and had to be attacking that elderly Indian gentleman. But it was a total lie. And Nick Sandman sued the Washington Post and received millions of dollars. If Facebook and Google and Twitter want to do that, if they want to be able to say yes to this and no to that and not allow freedom of speech totally, then they need to have that federal protection and others jerked from them. I'm sure they have some great tax benefits too. They need to be jerked too. If they want to live in the free market and choose to print or not to print what they want, good. Get out there in the free market. You're not having liability protection anymore. If you want to go hold stuff back and not be a free and fair, that's what they present themselves as. Oh, we're just a neutral platform for the exchange of ideas. No, you're not. You're not neutral. You choose some ideas, the ones that attack President Trump, and you suppress other ideas, like the Hunter Biden laptop story. It's unbelievable. It doesn't matter, as I've said before, whether or not the Hunter Biden laptop story is true. The point is, it's within 30 days of a presidential election, which makes it highly newsworthy. But they know it would hurt their preferred candidate because most of it's probably true. It may have implicated Vice President Biden himself. It certainly implicates Hunter Biden, his son. Didn't run it. Didn't let the story break. Shut down that article by the New York Post. The New York Post is one of the oldest and largest news publications in the world. They shut that article down that it would have put out through Twitter. Shut it down. So they're dishonest. They're not neutral arbiters of information. They make highly partisan and personalized editorial decisions. And if they're going to do that, then they need to have all their federal benefits jerked from them. Go compete in the marketplace now, Facebook. Go compete there, Twitter and Google. Y'all are highly editorializing and acting like, Oh, we exchange, I'll put all ideas out here. No, you don't. The hell you do. Anyway, so that's what happened this week. And I know I took a little while doing that, but I always want to try to, as best I can, relate this class to what is going on in this world. So when you hear people say idiotic things like, oh, the Constitution, that old document, what does it mean anymore? You've seen 4 days ago what that document means. Free exercise. You can't pick and choose. You can't favor some people's activities like going to get a bottle of wine or bicycle or go to a massage parlor or an acupuncturist. Can't say that's okay, that's essential, and then shut down people's right to worship. Free exercise is right here in the Constitution. Massage parlors and liquor stores and bike shops are not right here in the Constitution. Free exercise is right there in the First Amendment. Straight up. It textually does not get any clearer than that. So it's so encouraging to see Justice Gorsuch's concurrence and the whole court's holding. But what I want you to know is that was only a 5-4 decision. And these battles are going to keep coming up. And people say, let me tell you something else, and then I promise you we'll move to the 10th Amendment. I want you to please keep this principle in mind. The media loves to break everything down into categories, liberal, conservative. And because I want people to understand what I'm saying, I use those labels sometimes too, a conservative justice, a liberal justice. What I mean when I say a conservative justice, I'm not talking about what their political view of life is, their political philosophy. That's what's not supposed to come into the equation. When I say a conservative judge or justice, I'm talking about one that's faithful to the words of the text. You remember way back in the beginning, we talked about textualism. What do the plain words say? We talked about originalism. What was the meaning of the framers at the time they drafted the document? Textualism, originalism. We talked about judicial activism and strict constructionism. That's what I mean when I say a conservative judge. I don't care what the judge's political views are. I want to know if they go make things up from the Constitution. You know, I know best. I'm a powerful, life tenured federal judge. I know best. I don't really care what the people's representatives did. Congress, those people are kind of stupid. They're not as smart as me. The Senate, those senators, they may be smart, but they're not as smart as me, a federal judge. So I'm going to decide myself what this means. No. When I say conservative, I mean, what do the words, the right to keep and bear arms shall not be infringed? What does that mean? It ought to mean what those words say. Not, well, you know, the framers, you know, that's 243 years ago. They were talking about muskets. They never could have thought about rifles or machine guns or AR-15s. Wrong. The framers put in place principles. The framers couldn't possibly have listed every single right we had. The Constitution would be thousands of pages long, kind of like the federal code is. No, they didn't put in place specific, some are named rights, but as much as anything, they put in place principles. So it doesn't matter that the AR-15 could never possibly have been imagined by the drafters of our Constitution. What they were protecting was the right of people to defend themselves and their families and their property. That's why the right to keep and bear arms is a principle, not just a specific right to own a shotgun. You know, people always say, and this is one of the best rejoinders I've ever heard about the Second Amendment, then I promise you we're going to the 10th. But when it's all tied together, I got to tie it together, and I want you to know that. People say about the Second Amendment, oh, you don't know, you don't need an AR-15 to go deer hunting or duck hunting. And of course, the response is, right, but I'm not worried about the deer or the ducks attacking me. So that's why the correct analysis is not whether I need an AR-15 to go deer hunting. It's not the deer that I expect to attack me and my family. So that's where that argument loses and the Second Amendment wins. All right, that's kind of a good place to segue into the 10th Amendment, and that's what we're going to do. The mighty 10th, as I call it. But y'all remember that case we just went over, and hopefully you'll see my article. It'll be out there, but then you can tell your friends, you can be knowledgeable because we just went through my article. Okay, the 10th Amendment, we finished last time with the 9th. The 10th, keep in mind, as I said at the end of the 9th 2 weeks ago, the framers were still worried that maybe they hadn't made it absolutely clear that the federal central government was only going to enjoy or be entitled to those rights, could only exercise those powers that are specifically enumerated. Unlike the principles in the Constitution, they were talking about these specific limitations on the federal government. They intended to be specific there. And here in the 10th Amendment, like in the 9th, those men were normal men, as I've said before. Our framers had seen war and poverty. They had seen bravery and cowardice. They knew wealth. They knew, poverty. They'd seen famine. They'd seen disease. They'd seen the very best of people, the worst, joy, envy, rage, jealousy. They were real people. They just finished the 9th, and then they said, because the 9th is that, and again, I'm going to bounce just to the 9th because it ties together. The enumeration in the Constitution of certain rights, just because we've said certain things here, shall not be construed to deny or disparage others retained by the people. So again, that's the 9th Amendment. It's like they got stressed out and a little paranoid. The 9th and 10th come right after each other. So they did the 9th, and the 10th is kind of just another way of saying the 9th. It's like they're saying, just in case these generations to follow did not understand the first 9, we're going to put the 10th in there and spell it out again. What are they spelling out? When most people think of the 10th Amendment, they think of states' rights. The powers not delegated to the United States by the Constitution, which means to the federal government, nor prohibited by it to the states. So those powers not given to the federal government by the Constitution, nor prohibited by the Constitution to the states, are reserved to the states respectively or to the people. Okay? Those, again, the one prohibited by the states, we have that come up sometime, but the most important part of this sentence, and it's just one sentence, that's how strongly they felt. They just wanted to drop this in there again. The 9th Amendment is just one sentence. One sentence. The framers thought it was important. The enumeration in the Constitution, this is the 9th, of certain rights. The enumeration, meaning we've numbered them out, we've listed them. However, our listing in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, meaning in the 9th, just because we didn't write it all out, don't think the people don't have these rights, because if we didn't specifically give them to the federal government, the people do have these rights, okay, and the states. That's the 9th. The 10th, again, one sentence. It's really, to me, insightful that they did it in one sentence, like the right to keep and bear arms in the Second Amendment. The powers not delegated to the United States, meaning to the federal government, by the Constitution, nor prohibited by the Constitution to the states. So those powers we haven't delegated to the federal government and those powers we haven't prohibited to the states are reserved to the states and to the people. I mean, and this is how I describe it. The 10th Amendment was included in the Bill of Rights. You know, the Bill of Rights is the first 10 amendments. The 10th Amendment was included in the Bill of Rights to further define the balance of power between the federal government and the states. How so? Because the amendment says that the federal government has only those powers specifically granted by the Constitution. Only those powers. Now we know what a lot of them are. We've been over a lot of them. What are some of them? They include the power to declare war. That's specifically spelled out in the articles. Remember, we went over every article. The right to declare war, to collect taxes. That's also literally in the Constitution, in the articles. To regulate interstate commerce, business activities. We know that. We know intrastate, typically the states have the greater power. As long as everything being regulated is in Louisiana and doesn't cross state lines, then the state is going to have greater power, although there's always exceptions. But definitely when something crosses state lines, say there's a business that is based in both Louisiana and Texas and crosses state lines, crosses the Louisiana-Texas line, the federal government is going to be able to regulate that through interstate commerce because it's two states. But intrastate, keep in mind, the powers like the state's police power, which is why the president can't tell the governor to let him send in troops. Although, in my view, he could invoke the Insurrection Act. We went over that, but that's not part of my example. Governors are supposed to make those decisions about what goes on in their state. If they need help, they absolutely can ask the president for help. But a lot of these, in this last year, in 2020, a lot of these governors have not asked, like in Seattle, Washington, in Minnesota, in some of the other, Oregon, some of the other crazy places where people have burned their cities down and shot people and rioted and looted. Those governors and mayors never asked the president. So, but the 10th Amendment is about those things. If it's not specifically given to the federal government, the right to life, liberty, and property cannot be deprived without due process of law. That's powerful. But there's many others. The elections of presidents, the elections of U.S. House, U.S. Senate. We've been through all of that. Please remember those things we've been through. The 4th Amendment, the 5th Amendment, the 6th Amendment, where the rights we have against criminal prosecution and unreasonable search and seizures, 4th Amendment, all that stuff, those are powers specifically given to the federal government. But all the ones that aren't are with the states. So any power not listed, says the 10th Amendment, any power not listed is left to the states or the people. And although the 10th Amendment is one sentence, it doesn't specifically say what those powers may be. The U.S. Supreme Court has ruled that, again, commerce that occurs strictly and only within the state of Louisiana, strictly and only within the state of Texas or Georgia. I know there's some Atlanta people listening tonight. Thank you. Oregon, we have one in Oregon. Only in your state. Your state legislature and your governor are going to have much greater say over it than if it crosses state lines. So some of those areas are marriage, divorce, adoption, commerce, again, strictly in your state. Local law enforcement activities that come under the state's police power or the local municipalities' police power. Those things are, according to the 10th Amendment, left to the states and the local government. So that's what the 10th Amendment means. Right on the heels of the 9th Amendment. They're both saying the same things in a slightly different way. But here's the large message. If we haven't given it to you clearly and explicitly, spelled it out, enumerated, all powers remaining go to the states and to the people. That's hugely important. Again, it goes back to something we talked about on the very first night. This form of government these framers were setting up is a system of co-federalism. Co-federalism, meaning the federal government and the 50 states are co-equal sovereigns. That is what they are supposed to be under our Constitution. Co-equal sovereigns, equally powerful. Okay? You can look around and say, my God, as I've said before, this federal government's overwhelming. It's in every aspect of American life. How can you say the states are equally powerful as the federal government? And I agree with you. The federal government is way too powerful, but it's supposed to be the way I've described it. Co-equal sovereigns, equally powerful. And the 10th Amendment is yet another way, along with the 9th, of making that point clear. All right, where are we? God, it always flies. All right. This is the 11th Amendment. In the simplest terms, I want you to understand it like this. Sovereign immunity. 11th Amendment of our Constitution deals with what is referred to as sovereign immunity. What is sovereign immunity? Well, what is a sovereign? A state or a country, right? a distinct political entity. That's a sovereign. The U.S. is a sovereign. Louisiana is a sovereign. Sovereign immunity. So the immunity of a sovereign. Well, the 11th Amendment, what does it mean? Okay, sovereign immunity. What it says, the text of it is that the judicial power of the United States, meaning federal courts, federal power, shall not be construed to extend to any suit, any lawsuit, in law or equity, and mostly here we're talking about law, but in law or equity, commenced or prosecuted against one of the United States, like Louisiana. I'm going to explain this, but let's get the words right first. This is the literal text. As my law professors used to say to me, Mr. Alexander, I can't imagine any better place to begin than the text, the actual words. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of a foreign state. What does that mean? It's very important. After the Supreme Court, here's a little history. History is interwoven with constitutional law, just like constitutional law is interwoven with history. After the U.S. Supreme Court ruled in 1793 that 2 South Carolina men could sue and collect debts from the state of Georgia. They were from South Carolina. It's like Royal in Louisiana suing someone in Texas, suing Texas to collect a debt, suing the state of Texas to collect a debt. 2 men from South Carolina sued to collect debts from the state of Georgia. So these 2 South Carolina men were suing in its formal capacity the state of Georgia. The state of Georgia was actually the name on the lawsuit. These 2 men, Robert Jones and Samuel Johnson, are suing state of Georgia. After that happened, states' rights advocates, people who said, you're not going to start letting our state be sued by people in another state, or we're going to have another civil war. Seriously, this was in 1795. I mean, the Civil War just ended in 18. This occurred before that. I'm sorry. This was not long after the Revolutionary War. Anyway, 1793. I'm sorry. I got my dates backwards. But it would have applied then too. It didn't even get that far. It didn't even take that long. States' rights people, and again, after the framing of the Constitution, the reason it was difficult to get it ratified is because states' rights people, notwithstanding everything we've been over, still did not believe that the Constitution's power to give the federal government was limited enough, even with the 9th Amendment, even with the 10th Amendment, even with all the other restrictions on Congress, on the government. A lot of these states' rights people still didn't think that was enough. So what did we have here? 1795, these 2 men from Georgia sued the South Carolina, 2 men from South Carolina sued the state of Georgia. States' rights advocates in Congress proposed what became the 11th Amendment. This amendment specifically prohibits federal courts from hearing cases in which a state is sued by an individual from another state or another country. It's not like Iran is, maybe they'll try, but if Iran wanted to sue the United States or wanted to sue the state of Louisiana, it couldn't go into federal court and do it. The country of Iran could not sue the state of Louisiana in federal court. Couldn't do it. They'd have to find some other way. So from hearing cases in which a state, but more likely is which a state is sued by an individual from another state. So we're not going to be able to have again that case where those 2 men from South Carolina sued literally the state of Georgia for debts that they said were owed them. So protecting states from certain types of legal liability is known as sovereign immunity. And as initially interpreted, the 11th Amendment did not bar lawsuits against the states when a matter of federal law was at issue, nor did it prevent suits against a state by its own citizens. Now, Royal in Louisiana wants to sue Louisiana in federal court. It didn't address that right then. But listen, over time, though, the U.S. Supreme Court has expanded its interpretation of the amendment, the 11th Amendment again, sovereign immunity, expanded it to reflect a broader view that states were immune from all suits in federal courts without their agreement, which of course is unlikely. Most states are not going to agree to being sued in federal courts, even by people in their own state. So that's what we have, sovereign immunity. Certainly, citizens of one state cannot sue in federal court. Citizens, the state, another state, cannot sue another state in federal court. Citizens of Louisiana cannot sue the state of Texas in federal court. Now, they can sue other citizens from Texas. That's called diversity of citizenship, and it's absolutely a ground to be in federal court, and also federal question jurisdiction. But Louisiana residents can't directly sue the state of Texas for something for something they think is owed to them. That is the doctrine of sovereign immunity. I'm the sovereign, Louisiana or the United States, or Texas. In this case, we're talking about states, Texas, Louisiana, Georgia, Oregon, and I'm not consenting. I'm immune from being sued because I'm not consenting to it. And that's why the 11th Amendment is there. And I think it was important for states' rights purposes not to allow a citizen from Texas to sue Louisiana directly in its formal capacity as the state of Louisiana. All right, that is the doctrine of sovereign immunity. It's specifically federal courts and not hearing a case. So if you could get, there's other ways to work through things between the states, but we're talking about federal courts here. Federal courts. The states can work out things. Someone can be sued in Texas from Louisiana. There's a certain procedure you have to go through. It takes longer. It involves something called letters rogatory. You have to get a court here in Louisiana to send a particular set of documentation and requests and instructions to a state court in Texas and ask that state court in Texas to impose its own power, because a state court in Louisiana doesn't have power over a citizen or a business in the state of Texas unless that business has consented to what we call minimum contacts. But that's a whole nother discussion. What I mean is we're talking about federal courts and not allowing citizens of one state to sue the state itself, another state itself. Louisiana citizens suing the state of Texas. And that's what the 11th Amendment is all about. And occasionally it comes into play, but not that much, but it's still important. I just realized I only had 2 minutes. Well, I'll tell you this, and it's the Electoral College. And we kind of talked about the Electoral College last time. A lot's going on. If Joe Biden does not end up with 207 electoral votes, and people say, Royal, you're crazy, this election's over. Well, it's only over if the Supreme Court decides not to hear it. But there's a case, the Bookvar case we've talked about, that's already pending before the Supreme Court. After Justice Ruth Bader Ginsburg died, it was 4-4. 4 justices, including John Roberts, shocker, and 4 who wanted to hear it. 4 who didn't, 4 who did. They were deadlocked. So the petition wasn't rejected or accepted. So it's still sitting there before the Supreme Court. That case involves Pennsylvania and the stretching out, adding days to the counting of ballots, the days of voting. That could easily be addressed. And with the authority to address that case, to me, that would give the Supreme Court the authority to address the problems in all these other states as well, including the Dominion voting system, which was created for nothing but flipping votes from one candidate to another in real time, or just grabbing, putting in a trash can, and deleting votes for a candidate. So that all that's still live. If Joe Biden on October the 6th does not have 270 electoral votes, this is going into the House of Representatives. if it goes into the House of Representatives, every state gets one vote, which is why there is hope across the land. Not according to their population, according to their statehood. One vote, which means Louisiana gets one and California gets one. Those 50 state delegations, because the state legislature is going to decide how it goes, they'll decide. And because 50 states right now are what you would call GOP, Republican dominated, if it does get into the House of Representatives, I would expect that President Trump would be returned as president. So we're going to talk more about the 12th Amendment, but it's the Electoral College. It's breaking it down. It modifies some things, change some things, but the Electoral College itself is brilliant. Because as I've said many times, if we didn't have the Electoral College and our national elections were based on just the raw vote, candidates would never go to tiny states like ours. Louisiana is a small state. Maine is a tiny state. Rhode Island is a tiny state. Wyoming is a tiny state. These candidates would not waste their time in states with so little population. They would spend it all in the big urban populations. California has, I think, 34 million people. They're going to spend all their time in California or New York or Florida or Texas, but they're never going to the small states. The Electoral College, but we don't elect people by the raw vote. The Electoral College requires, in its brilliance, in the framers' brilliance, it requires candidates to take into account the electoral votes in every state, all 50. Now, someone like President Trump may assume he's going to win Louisiana's electoral votes or the Republican, because Louisiana is considered a red state. But they still have to be sure of that, because without Louisiana's electoral votes, he would lose. So they don't spend a ton of time here because they want to spend their money where they expect not to win, where they have to fight, like in the battleground states. But they still can't ignore Louisiana. They can't ignore Maine. Maybe Maine only has 1 electoral votes or 3. If they don't have 3, they could lose. Those 3 could stop them at 267 when you have to have 270 to become president. So they'll spend time in the battleground states because that's where it's so close and they need those electoral votes, and they think we're not. That's why the National Democrat Party doesn't really fight much in Louisiana, because it's an overwhelmingly red state. But in other states, they fight hard. But, and there's other states Republicans don't spend time, as much time, like New Jersey or New York State. A Republican's just not going to win those states, most likely. But in those battleground states, both sides are going to spend every money for every vote down to every county and every precinct to try to win those states, because those electoral votes they desperately have to get to 270. Anyway, we'll finish we'll do the Electoral College, the 12th Amendment, next time. But let me see if there's any questions. That's as far as I'm going to go. Here's one. This is one from New Orleans. I think I know who this is. Why isn't the 10th Amendment respected and used more often? I agree. Why isn't the 10th Amendment held up and followed more closely? I will say that it probably goes back to the court packing scheme of FDR in the late 1920s and 1930s and into the 1940s. He was going to enact his huge programs, these huge domestic economic programs that he wanted to enact. I think he thought that he needed to pull the country out of the Great Depression. I think he thought people need jobs. I don't care how I have to create those jobs. I've got to create jobs. It's not fair to second guess people with looking at hindsight. Hindsight's 20/20. But in the moment, things are not as clear. And so I still think what he did set a terrible precedent for the huge federal agencies we have today. But that's where much of it started. So the Supreme Court at that time was not going along with what FDR wanted. They were finding unconstitutional his efforts to force the states to do things, because that Supreme Court during that period really was following the 10th Amendment. But he threatened to enlarge the Supreme Court, to pack it. Have we heard anything about that lately? Packing the Supreme Court? Absolutely we have. To pack the Supreme Court so that he would get justices that allowed him to do what he wanted to do, FDR, with his domestic program. From that time forward, from the 30s and 40s, for the last 80 years, the Supreme Court has allowed, primarily through the Interstate Commerce Clause, the Congress to regulate things that the 10th Amendment and the 9th Amendment would make pretty clear are state prerogatives, state priorities that shouldn't be dictated by the Congress. That has gone on for 80 or 20, 30, 60, 80, maybe 90 years. But certainly, I would say in the last decade, maybe the last 20 years, the U.S. Supreme Court has begun to curtail the power of the Congress through the Interstate Commerce Clause to regulate state activities, okay? Starting to tighten it up and say, no, Congress, you've gone too far. You know what would have been a huge example? Obamacare. Now, again, briefly about Obamacare. Obamacare was argued for 2 years in the courts under the Interstate Commerce Clause, that the Congress does have the power to somehow force me, an individual American citizen sitting in Shreveport, Louisiana, force me to buy health insurance. Where does the power to do that come from? If you can force me sitting in my living room in Shreveport, private citizen in my home, to force me to get out and go buy health insurance, then what can the Congress not do? That was the heated constitutional argument on both sides, because the people in favor of Obamacare that said the Interstate Commerce Clause can reach that far argued, oh no, this is going to affect 1/6 of the entire American economy. Surely it will impact interstate commerce. It'll impact the whole country. So because it affects interstate commerce, Congress should be able to regulate. That was their argument. What was the counter argument for states' rights? The 10th Amendment argument. No way. No way. If you can force someone to go do something, people say, we force people to get driver's licenses. No, we don't. People don't have to drive. Hunting licenses, people don't have to hunt. Marriage licenses, people sure don't have to get married. Those are not the same. Those are not equivocal analogies. But here, if I don't get health insurance, I'm going to be fined. What if the fact that I didn't have health insurance in the first place is because I couldn't afford it? And now that I don't have it, you're going to fine me for not having it, when if I'd had the money in the first place, I probably would have bought health care. You see how just really backward thinking, that analysis is totally backwards. The conclusion is like a tautology, except it doesn't follow the first thing from the second. That's a non sequitur, we call. But here, you're going to fine me for not having health insurance when maybe in the first place I didn't have money to go buy the health insurance. But now that I didn't buy it because I didn't have enough money, you're going to fine me, which I also won't have enough money to pay. You see how, but the argument was all about the Interstate Commerce Clause. So what did Justice Roberts do? What did he do? He knew that. And I think a lot, again, I'm not defending him. I'm just saying he's the Chief Justice. I think he knew the court would be considered once again political. I think he ought to be worried more about the Constitution than he does about how the Supreme Court is viewed. But I'm not there, and I'm not judging him, although I disagree with him often. I think he wanted to kill two birds with one stone, or thread the needle. And how did he do that? He, I believe, did not want the Interstate Commerce Clause to be stretched so far as to force Royal, sitting in his own home, to go and buy health insurance. I don't think he thinks the Interstate Commerce Clause should extend that far. I think he thinks the 10th Amendment is stronger and should have blocked that. So I don't think he wanted to agree with the ruling based on the Interstate Commerce Clause, but I do think he wanted to affirm Obamacare so it didn't appear, and again, I'm speculating, but I think there's grounds to affirm my thinking. I think he didn't want the court to be viewed as political as he thought it was in the year 2000 in Bush v. Gore, and maybe in other decisions since then. Oh, those are just the Republican justices who do that. Those are just the liberal Democrat justices. That bothers him, I think, deeply, because he's correct that the Supreme Court, our federal judiciary, our courts in general, across the board, have to be impartial, fair and impartial, because it's how we're going to resolve right and wrong. And if people think they cannot get their fair day in court, like these ballots in Pennsylvania and across the country, but that's the right to vote. That's a separate analysis. What I mean is, I think John Roberts wanted to affirm the Obamacare statute, but he didn't want to do it through the Interstate Commerce Clause. So you know what he did in the last second? He said, oh no, this is just Congress exercising its taxing power, which of course is right there in the Constitution. That never was how it was argued. Obamacare was never argued that it could be supported based upon it being a tax. But that's what Justice Roberts used to affirm it. And in a way, it's brilliant, because the power to tax is right there. The power to levy a tax. We know that. We went over it. It's one of the articles right there in the beginning. So you see what he did. He stopped the Interstate Commerce Clause from being stretched to include forcing me to go buy health insurance. But he still affirmed Obamacare by saying, we're going to say this is merely, even though no one had argued it, no one argued the taxing power. Everything was argued supporting Obamacare based upon the interstate commerce power. But here, Justice Roberts flipped it and said, we're going to treat this as though Congress has chosen to exercise this under its power to tax. And this tax we're putting on American citizens to go and buy health insurance. And that's how he affirmed it. But back to the question, the 10th Amendment and the 9th Amendment and all the other protections. Keep in mind, the Constitution was not put in place by our framers to limit the freedom of the people. It was put in place to limit the power of the government, not the people. All right. That's the only question I see. That is a good place to wrap up. I'm sorry, it's 7:13. I hope you stayed with me, and I will see you again at the next date. I don't know if it's in 2 weeks, but we'll send out a notice. Thank you for joining us.